Get ready. 3, 2, 1, start. This appeal has been filed against the judgment of Delhi High Court dated 18/11/2009 dismissing the criminal appeal filed by the appellant, by which appeal the judgment dated 26/3/2008 for the Appellate Tribunal for Foreign Exchange in appeal number 622 of 2004 filed by the appellant was challenged. Brief facts of the case giving rise to this appeal are as follows. Modi Xerox Limited was a company registered under the Companies Act 1956 in the year 1983. Between the period 12/6/1985 to 21/11/1985, 20 remittances were made by the company through its banker, Standard Chartered Bank. The Reserve Bank of India issued a letter stating that despite reminder issued by the authorized dealer, MXL had not submitted the exchange control copy of the custom bills of the entry postal as evidence of import of goods into India. Enforcement Directorate wrote to MXL in the year 1991-93 for supplying invoices as well as purchase orders. MXL on 9/7/1993 provided for 4 transactions and chartered accountants' certificates for balance 16 amounts for which MXL bankers were unable to trace old records dating back to 1985. MXL amalgamated and merged into Xerox Modi Crop Limited, hereinafter referred to as XMC, on 10/1/2000. A so-called notice dated 19/2/2001 was issued by the Deputy Director, Enforcement Directorate to MXL and its directors, including the appellant. The so-cause notice required to show cause in writing as to why adjudication proceedings as contemplated in Section 51 of the Foreign Exchange Regulation Act 1973, hereinafter referred to as FERA 1973, should not be held for contravention. Xerox Modi Corporation Limited, successor of MXL, replied the so-cause notice dated 19/2/2001 vide its letter dated 26/3/2001. The Directorate of Enforcement decided to hold proceedings as contemplated in Section 51 of the FERA 1973, read with Section 3 and 4 of Section 49 of FEMA and fixed 22/10/2003 for personal hearing. Notice dated 8/10/2003 was sent to MXL and its directors. Notice dated 8/10/2003 was replied by the appellant via its detailed reply dated 29/10/2003. In the reply, the appellant stated that he is a practicing advocate of the Supreme Court and was only a part-time, non-executive director of MXL, and he was never in the employment of the company nor had executive role in the functions of the company. It was further stated that the appellant was never in charge of nor ever responsible for the conduct of business of the company. Stop.